My name is Rumbidzai Bvunzawabaya from Tulia, and we are an organization that's based in Coventry. We support migrants with advice and also with other types of support. We provide emergency accommodation, we signpost people to other organizations, and we work with various organizations supporting migrants, all different types of migrants. So long-term overstayers, new entrants, people who have arrived on health and social care visas, people who are sponsored tier 2 migrants, graduates, students. So all sorts of migrants. If you're a migrant, we help you. The only type of cases that we don't take on are asylum at the moment, but we do everything else. So today, this talk is perhaps geared towards people who are carers or skilled workers in varying in different categories and sectors, because the issues for skilled workers affect people almost the same in terms of cancellation of their visas. It doesn't matter if you are working as a nurse, a carer, an accountant, a butcher, construction, the rules are the same. So I'm mainly talking today about cancellation of visas or curtailment of visas. Same thing, just different terms. And they are basically the terms cancellation of visas, cancellation of permission to enter or permission to stay are terms that are included in the immigration rules. And in the immigration rules, that the ones I'm referring to are the immigration rules that were introduced on the 1st of December 2020. So the term cancellation is widely used in the immigration rules and replaces the term curtailment. So sometimes you'll hear somebody saying the visa has been curtailed, and you'll hear someone else saying the visa has been cancelled. So I'm speaking about cancellation of permission to stay and the circumstances in which that arises. And then I'm going to talk about some of the things that you can do and some of the things that you cannot do, and what you can, what options are available. If you've got any questions, please hold on to them. And I will only speak for about 15 minutes and then give people the opportunity to ask questions. And I'm mindful that people are still joining, but I will be able to answer questions as we progress and as we go on. Thank you, everyone. I'm seeing where you are joining from. I'm hearing some people saying, I can't hear. I think it must be you, because there are others who can hear and the sound is clear, but there are others who are saying, I can't hear. So I'm not sure. If you cannot hear, it might be something to do with you and your microphone. So I am sorry if you cannot hear, but I think most people are saying they can hear. Okay, you can now hear. Wonderful. Thank you so much. So we're talking about cancellation of visas, which is affecting a lot of people, where the Home Office is cancelling or curtailing visas. And the terms are interchangeable. So it's just the difference is based on the definitions in the Immigration Act and in the immigration rules. So I will refer to cancellation of visas. I'm not going to go into where it is in the rules, etc. But suffice to say that the Home Office and the Secretary of State has got the right to cancel a person's visa, individuals leave to remain at any time. So even someone who has got indefinite leave to remain, that indefinite leave to remain can be cancelled as well. So the Secretary of State, they can require you as a person to surrender your BRP, and they can vary or cancel your leave to remain at any time. And the circumstances in which they can do that. They can cancel your leave to remain with immediate effect. So the Home Office, the Secretary of State, they've got the power to cancel with immediate effect, or they can give you 60 days. They can cancel it and give you a period of time within which to apply for a new visa or switch or do whatever you can, you choose to do within a period of 60 days. Or any period, in fact, it doesn't have to be 60 days. So they have the power to limit your visa to even a month, even to a few days, or even to cancel it with immediate effect. And it's important to know that, and to know in what circumstances they choose to do that, or when they will do that. So some of the reasons that are there is where I think the most common reason at the moment is where your employer who has, if you're a skilled worker, where your employer either has stopped your employment and you haven't been able to get other employment, and the Home Office gives you a period of time to then find a new employer, or to leave the country, or to make another application in a different category, or your employer loses their right to sponsor you. So where a sponsor's license is revoked, then the Home Office can cancel your leave to remain. The Home Office can also cancel the leave to remain where you have made false representations. And this is something that I'm starting to see a lot more of, which is even why I'm doing like this particular session today, because we're starting to see cancellations without
2 in the
even
morning or 2 in the
an
afternoon?
extra days, based on people making false representations. So providing false information, failing to disclose material facts in support of an application for leave to enter. So I don't know if any of you saw a newspaper article which was talking about fake marriage certificates coming out of Harare. So where people have used false documents in support of an application, the Secretary of State, the Home Office, has got the power to cancel a leave to remain for both people who are involved. So the husband and the wife, if they've made false representations to say we are married, and they've used false documents, or using false birth certificates for children, or putting back the years, like by 2 years, to make a child under 18. So, people do all sorts of things. And these are issues where the Home Office has got a right to cancel a visa. And usually where there's false documents that have been used, false representations, or where there's been a failure to disclose material facts, the cancellation is usually immediate, without the opportunity for administrative review or even 60-day grace period. So this is something that we are seeing coming through quite a lot. And the reasons why they find out, people tell on each other, people report each other, people fight and fall out, and they all sorts of reasons. Then they tell the Home Office. Of course, the Home Office has got the information and they act on it. So, for example, you were married and it wasn't genuine. Maybe your sibling finds out, or your spouse or your original spouse finds out. So many different types of reasons. So that's one area where the Home Office can cancel immediately. False representations, presenting false documentation, even if you say it was presented by an agent or something else, they still are quite strict in the application of the law in that. Another grounds that we're seeing cancellations, which is becoming more common, is a failure to comply with conditions which are attached to your leave to remain, to your current or previous grant of leave to remain. So now I don't want to just be frightening people, because some people get so anxious and worried, but it's important to know, because knowledge is power. So it's important for you to know what you should do and what you shouldn't do. So you often hear us, people talking about 20 hours. Be careful, because you're supposed to work only for 20 hours. And if you work more than that, if you encounter in your second job, if you encounter the Home Office on maybe a routine inspection of your second job, and they find that you're working more than 20 hours, they can cancel your visa because you failed to comply with the conditions which are attached to your leave to remain. And what the rules say is attached to your current or previous grant. So you can get a switch and move on, but you had breached the conditions at another time, and they can cancel your visa on that basis. There is a lot of conversations around this, and I think these are some of the things that we need to campaign about, because where people perhaps are not getting enough hours and they're having to work somewhere else, it may be that they're forced into that situation, because if they are not working, they may end up committing a crime, or they may end up being exploited or finding other ways to survive which are not good. So these are areas that we are taking up and having conversations with decision makers to say some people are actually being put in a very difficult position where the only work they're getting is outside of their main employment, because the main employer does not have work for them. So they're working more. It's not lawful to do it, and it can cause your visa to be cancelled. So as it stands, it's important to know that, so that you do not get caught out and say, I didn't know, because it's important to know the consequences of that. And there have been people who have had their leave to remain cancelled. You may know some, and we get day by day, we always get referrals and issues like that being referred to us. So it's important to stick to the conditions of your visa as much as you can. And if you have an employer where there's no hours, don't relax and work at the place where you're doing maricho, where you're working somewhere else, your second employment, and become comfortable there, thinking that you are okay. You're not okay. You need to find a switch, and you need to get out of that situation where you are breaching the conditions of your leave to remain, because your leave to remain is attached to that butcher where you're working, it's attached to that construction worker, it's attached to that domiciliary care place, or where you feel you don't like dom care, so you'd rather do more hours at the nursing home than where you are supposed to be employed. That is failing to comply with the conditions of your permission to stay, and can cause your visa to be cancelled. Another reason is where you fail to maintain or accommodate yourself and your dependents without recourse to public funds. So where you are failing to support yourself and your children, and you are resorting to the state, they'll say, when we gave you this visa, we said no recourse to public funds. You need to work and look after your family. So the fact that you are not being able to do that, I think it's better we cancel your visa. So they are allowed to do that and say it's better you go back, because they don't want the government to be having thousands and thousands of people who they have to support. So even if they give you, for example, support for a period of time. They will keep encouraging you to say you need to make a plan to go back. And then you may find that the Home Office will then cancel the visa that you're on because you're a skilled worker, but you can't afford to look after yourself and your family. So it's better that you go back to your country of origin, and so they can cancel your visa. But I have to perhaps also say, hear what I'm saying. If you are destitute with your children, don't be homeless or put yourself sleeping in the car with your family. You are allowed to get support from social services and from other organizations that help. But you must be aware that it can have the consequences where your leave may be cancelled. So even though you do that, there is provision in the rules to say a failure by an individual to maintain or accommodate himself and any dependents without recourse to public funds is a ground for cancellation. It's a possible ground. So that's a possibility. If you are an undesirable person, like it's undesirable to permit you as a person to remain in the UK because of your conduct, because of your character, your associations, or the fact that you represent a threat to national security. So that may be offending, persistent offending. Persistent offending can even be driving offenses, drink driving, committing other offenses as well. So a person who is a persistent offender, a person who is of a shady character, those are reasons that they can. So shady, I'm just saying that, but your associations, if you're associating with people who may be a threat to national security, those are issues that they'll take very seriously. I'm going to wrap up in 5 minutes. So I'm giving there's so many reasons that can be given: using deception in seeking leave to remain, knowing that you're coming here for a job where there is no job, you're well aware of it, and you may be complicit in it, that you decided that you were going to purchase your entry to the UK knowing full well that there is no work for you. That's using deception in seeking leave to enter the UK. Those are all grounds that can lead to cancellation of your visa at any stage. And so those are grounds that the Home Office have got in their schedule. And the other one is where a person has committed offense within the first 6 months of being granted leave to enter, and this has resulted in a period of imprisonment. So where you're put into prison and a person has been convicted of a criminal offense in the UK or even overseas, for which they received a custodial sentence of less than 12 months, your leave to remain can be cancelled. So there's a wide range of grounds and reasons why your leave to remain can be cancelled. And as I've said, the Secretary of State has got the power to cancel immediately or to cancel, to give you a period of time within which to either make a different application, make another application, or return voluntarily to your country of origin, so they can give you time to do that. The other grounds that I'm seeing is where a person has been involved in a sham marriage. That is another big ground, and using deception, where we are seeing quite a large number of cancellations, sham marriages, failure to attend a biometric enrollment, failure to just comply with your grounds. I think I've covered most of them. I'm going to check if there's any questions, because I'm not seeing any questions.
Got some questions.
Quite a lot of questions. So I'll stop before I talk about what other things you can do. How to prove your right to work if you're on a fee waiver. Okay, I'll come to that just now. Right. Okay. Okay. I want to see if there's anyone who's got questions about what I've been talking about the reasons for cancellation and some of the areas. So, somebody's asked 20 hours. 20 hours per week. What about if you are paid monthly? Can the hours be worked disorderly as long as you don't exceed 80 hours a month? So it's 20 hours a week, for a reason. So that's how the hours are seen, not per month. So wording is very important. If it's written and says 20 hours a week, I always say to people, don't add, subtract, or try and add your own. You don't have to rewrite the law. The law is the law. It's 20 hours per week for a reason. If they wanted to say 80 hours per month, they would say that. So it's important to stick to the letter of the law. Even if you do 19 hours, it's better than to do 25 hours or 30 hours. I've seen students having their student visas refused on extension because they did more than 20 hours, and not even more by 30, but just like 23 hours a week. And that's considered to be a breach. So it's important to stick to the letter of the law. Dealing with the Home Office over time, I've been working in immigration law since for a long time. So if I say that the length of time, you guys will know how very old I am. But I was admitted in 2003 in England, 98 in Zimbabwe. So working within this sector for a long time. And so that's about 21 years. And the interpretation of the law is strict. You read it as it is. There's no need to put your own interpretation, like your own adding. So thank you for that question, because I know people always ask, what if this month I do this one? No, it's 20 hours a week. Let's just stick to it, because otherwise you can find yourself getting yourself into trouble. So it's really important. So yes, so the companies, can you kindly explain a situation where a company's license has expired or removed? How does it affect me as an employee and I didn't receive the 60-day letter? So where you see, because I know people are tracking companies to see what's happening. It's good to do that and to be aware of what's happening in terms of the company that you're working for. So if you see that the license, it says the license has been removed or it's expired, the sponsorship license can be suspended. And when it's suspended, the Home Office will be investigating to see whether or not the company poses a threat to immigration control, whether the company actually has genuine vacancies, if they actually have proper work, whether they are breaching the rules. So the Home Office will pause and say, we're just removing you from the register of sponsors, and we want to look deeper into what you're doing and to satisfy ourselves. So we help employers to retain and to keep their licenses. So when they get letters like that, we try and help to get the evidence together and try and show that they are legitimate businesses, they're actually trading, they actually have genuine vacancies, they're paying their people. If there may be breaches where they haven't been paying, then they can, they can pay people or do whatever they need to do to persuade the Home Office that they are not a threat to immigration control. The Home Office will then review the evidence and then make a decision whether to revoke the license completely, to continue suspending and make further inquiries, to reinstate completely, to put the company on an action plan, and then downgrade them to a B, give them a bit of time to sort out the issues, and then allow them to go back to being fully an A-rated sponsor. So it doesn't mean that if you see that they've been removed, it's not the end. It's a process. And that process can take time. You know, it can take 6 months. At the moment, the Home Office is busy. So it can take even 6 months for a decision to come back. They won't tell you when the license has been revoked. So it's important to maintain communication with your sponsor. The employer is the only person who will know if all of their representations and evidence, if the license has been revoked. So being suspended, it's not something to celebrate, because some people celebrate somebody's downfall. People are funny like that. It's not. It's just, it's an investigation which can lead to many things. So if you haven't received a 60-day letter, it may mean that they haven't had their license revoked. But if they've told you that we had a suspension, now it's being revoked, your sponsor should tell you that, to give you time to look for another sponsor. Some sponsors will challenge that revocation. We have helped sponsors to challenge that revocation and get the license reinstated by way of judicial review. There's a case that came out, it was published last week, another company I saw, where they went to the High Court and they won. So there's a process, a legal process that goes on. So whilst that is going on, you won't receive a 60-day letter, and you continue to be able to carry on unless your visa expires during the process. So if you haven't received a 60-day letter cancelling your visa, it may be that the process is still ongoing. But once the sponsor's license has been revoked, you may get a letter saying that you've got 60 days. Not everyone will get that letter. Sometimes the Home Office delays in sending that letter. Sometimes they intentionally give you time so that you can find a switch or find another employer. So they have a discretion as to when to cancel. So they can actually wait and give you time. So you'll notice that sometimes you only get that 60-day letter after 6 months, after 9 months, after a year. And that's because the Home Office is exercising their discretion not to cancel your visa immediately. So not having a 60-day letter is not something to wish for. Please don't have a fear of missing out. We get inquiries saying, how come I haven't received it? What do you want it for? Because that letter is not a good letter. It's nothing to hope for. It's nothing to wish for. All you need to do is to make sure that they know your email address, that your details are up to date. That's what you need to be mindful of. Make sure that you communicate with the Home Office. They know where you are, because you don't want the letter to be served to you and you don't get it. But if they know where you are, you check your email, check your spam, always stay on top of it. Check your right to work and just allow it. So if you don't get it, you don't get it. I think that's wonderful. If you haven't got it, keep looking for a switch. Keep looking and trying to secure your status, so that you can find another employer. So it's so I hope I've answered that question. So carry on. Yeah. Cancellation of indefinite leave to remain. Thanks, Tatenda, for asking that question. What reason could they have to cancel one's indefinite leave to remain if someone has been outside the UK for more than 2 years? So if you have indefinite leave to remain and you're outside the UK for more than 2 years, your visa will be cancelled, because you will not be staying here permanently. So they have a right to cancel it, because you then have to apply again as a returning resident. So you can always apply to have your indefinite leave to remain back as a returning resident. However, if you're in the UK, say you commit a crime your indefinite leave to remain can be cancelled if you're served with a deportation order and you've been sentenced to more than 12 months imprisonment. It can be, your indefinite leave to remain can be cancelled. If you obtained your indefinite leave to remain by deception, if you obtained your indefinite leave to remain by, telling lies or using false documents or giving false information, then it can be cancelled as well. So indefinite leave to remain, it's it's not always indefinite. Even British citizenship, if you used fraudulent means to get it, they can cancel it. So Pam says, on a skilled worker visa, am I able to resign from my current employer without another job? Use the 60 days to look for employment. So I want to explain about the 60 days first. The 60 days, you actually get a letter. So don't count the 60 days from the day that you resign. Your employer can't tell you that your 60 days are up. The Home Office writes you a letter and tells you that you are being given 60 days. So you can resign and look for a job. It doesn't mean that you have 60 days to do it. You have a period of time to do it, and you will then get the 60-day letter. But personally, I wouldn't advise you to do that. I would advise you to look for a job when you're at work. And if you can, I know there's different reasons why you may want to resign, but if you can stick it out at work and then just look for a job whilst you're there, and then resign after you've been given a COS, you've applied for your new visa, and you're holding your new BRP in your hand. Then you resign, give your notice, and go. Because if you act prematurely, you can find yourself in a difficult situation. Yeah. So so the nursery for children is not considered public funds. So those who are asking for the free childcare for children, the 15 hours, it's not a breach of your conditions. So there is a campaign. So I'll check about the childcare and come back to you as to, but the 15 hours is allowed for all children. And there was a campaign that was held by Praxis, which is campaigning for more hours so that all the children can get the same number of hours for all children, not just children who have got no recourse to public funds. So there is a campaign that's going on, right, which is for all children to get the same number of, right. So I'm going to share that petition with you in the chat. So the UK government, there's a petition that's going around that it should ensure that childcare system is truly universal and shouldn't exclude children because of the parents not having recourse to public funds. So the children whose parents do not have a restriction on their visas will be entitled to 30 hours of childcare support from the government. But that will not extend to children whose parents have got limited leave with no recourse to public funds. But for those children who they are entitled to 15 hours. So it's just important to check even with your nursery so that you don't take others which what you're not entitled to. Right. Thank you for... Okay, I'm just reading through the questions. I think it's better to answer the questions because it will answer what you need. Um, So, someone received a 60 days letter from the Home Office and you got a switch. I called the Home Office asking if my dependents can also apply with me. But they said if in your 60 days email, they didn't mention your dependents, they don't have to apply. Is that correct? So, so generally when you switch, you don't have to include your dependents if they still have leave to remain. And they will then only have to extend their leave once their leave to remain is expiring. Generally, when you get a cancellation or a curtailment letter, it applies to all of you. But it may be that due to an administrative error, your dependents didn't get the letter, which would mean that they haven't been given notice that their visas have been cancelled. I would, if funds permitting, I would just apply for everyone to avoid problems later on. So that usually the 60-day letter is for everyone, not just the main applicant. So generally, it would be important to apply, but I wouldn't know. Yeah, I can't comment on the advice that you were given by the Home Office, but just to be safe and prudent, I would apply for everyone. If somebody's asked if my main employer does not give me the hours, and you're not getting hours from your main employer and you're working 20 hours elsewhere, you've got to survive. I get it. But what's happening now is a lot of employers are actually not giving you the 20 hours if they don't have proof that you are working for your main employer, because the rules are quite clear that the 20 hours are supplementary employment and you should be working for your main employer and then adding on with the 20 hours, not that your 20 hours is your main employer or only employer. So you are in breach of your conditions. And if you do get unfortunate and encounter the Home Office, that would be and may be a ground for them to cancel your visa. So where you find that your main employer doesn't have hours, and I know that it's difficult, I get it. Honestly, I totally understand. And I'm just telling you the pitfalls and what the law says, but I understand the need to eat and to feed your family. So I get that. But it is a breach of your conditions because so it's important to also focus on looking for a switch so that you can be working for a main employer who is actually giving you work, because it will not end well, because if your main employer is not giving you hours, not even 1 hour, then it's only a matter of time before the Home Office comes and investigates them, and then that can lead to them losing their license. So it's a matter of time. So in the time that you have, really focus on applying for switch wherever you can get it in the UK. Don't limit yourself geographically. I understand the challenges that come with that, but that's what I would say. If you can get your driving license, get your driving license so that you can make you can explore all the options that are available to you. Someone asked if you switch to a student visa, would that change your 5 years to indefinite leave to remain? Yes, it would, because the 5 years is in the same category. So if you switch from a skilled worker to a student route doesn't lead to settlement. So you'd only get settlement after 10 years of lawful residence, or if you switch into another 5-year route of the different routes. So the 5 years has to be in the same route. Yeah. I hope that makes sense. I'm going to take a break and breathe. So if your spouse is the main applicant employer confirmed that they applied for an extension, but no feedback from the Home Office and visas are due to expire, how do you deal with this? So I'm not sure what that means. If they've applied for an extension of your visas, then you would wait for a decision. But if you are meaning that they've applied for a COS and you don't yet have the COS, yeah, if you don't yet have the COS to apply for the extension and the employer is waiting for them to come, that is a big issue across the sector. The Home Office is taking a long time to release the certificates of sponsorship for people to extend their visas. So you do have an option of applying for a fee waiver, no, applying for leaving the country and going back. That's number one. Or number two, some employers are assisting you to apply and explain on the application form that you're waiting for the allocation to come from the Home Office and providing evidence of the delays within the Home Office that they've requested and they haven't received them. So whilst your application is at the Home Office, they'll keep asking for a valid COS, but we've made representations to say there's delays. So on one hand, you're pushing the Home Office, trying to get the release of the new COSs. The employer has to work with you. So it's not something that you can do yourself, because they're the ones who can try and get priority. They can try and contact the MP. They can try and get the commissioners at the council to also push the Home Office. They can try and get the, just try everything as an employer to get a release of the COSs before your visas expire. So it's using everything at your disposal to try and get decisions to come through, but never let your visas lapse. Never, ever let your visas lapse. Apply whilst your visas are still valid. So it's important to also get legal advice about your situation. And one thing I want to say is it's your responsibility. So your immigration status in this country is your responsibility. If your employer does not have a certificate of sponsorship for you to extend your leave, they can only do what they can do. But at the end of the day, it's you who's going to become an overstayer if you don't do something about it. So it's your responsibility to get your own legal advice and know what to do. And make an application. Don't leave your visa to expire even by, please don't, because the Home Office can exercise a discretion and grant you leave to remain after your visa is expired, but they can just refuse it. And whilst you're an overstayer, you then lose your right to work, you lose your right to rent, you can lose your right to drive, you can lose your right to access healthcare. So it's vital that you do not leave your visa to expire or to lapse. Get advice, find a way to get around it, and ensure that you've got an application. It's always important to have an application there so that it can be dealt with at the Home Office. Don't sit with your visa whilst it expires and you're looking at it and blaming your employer. No, it's they are stuck because the Home Office is not issuing. They're delaying with the COSs, but ultimately it is your responsibility. So somebody's asked me, please, can I ask you something after the broadcast, because it's a bit private. You can book a consultation. So after this broadcast, it will be 9 o'clock. I've been up since 6. I've been working since 7, and I'm still working. So I'm talking to you is work. So I'm not going to be working after this broadcast. So I'm really sorry. I'm not going to be. You better put it here because you've got me here to answer. But after this, I'm going to sleep. So no, please don't phone me. Don't look for me. I beg. No. Um. Yeah. Switches are there if you keep looking. There's so many questions, and we always have a lot of questions, but I think some of them we can group them up into I'm gonna answer two questions. One from Iris, how can the 60 days be extended? So the 60 days can be extended by making it by switching to another employer. So that's number one. I mean, obviously you can switch to another employer. You can apply for a visa as a student if you've got money. Like, some people are doing like a year as a social work master's. If you've got a master's, and some people have got some money, they apply for a student visa, switch to like a master's in maybe social work or something, so that they can then get a job, or they just up their skills. So you could switch to student. You could switch to a spouse. Some people are meeting the love of their life, getting married. You can switch to a spouse. You can switch to, some people are parents of British citizen children, so you can make an application as a parent. You can make an application on exceptional compassionate circumstances. So if you are pregnant, if you are have got cancer, if you're sick, chronically ill, you can make an application outside of the immigration rules. If there's exceptional circumstances about your case, if you've got something that is different, that is unique about you, if you've got, some people have mental health breakdowns, if you have so many different grounds, if you're a victim of domestic violence, you can make an application outside of the immigration rules using for asking for further leave to remain. If you have got a fear of persecution, you can then go down asylum route, depending on your country situation and your personal situation. If none of the above apply, you can then try and apply for leave to remain outside of the rules for an extension for you to find an employer because of the circumstances of how you came here. Maybe you sold everything, you came here, you found you had no work, you ended up destitute or whatever, you were just looking for a switch. You can do that. And the cost for making that type of application is about £3,000, like the Home Office fees. This is not lawyers' fees. This is the Home Office fees. It's over £3,000 because you are charged the immigration health surcharge, which is 1,000 and I think 35 a year. So you usually pay for 2.5 years. You pay the Home Office fee of 1,048. So it comes up to a lot of money. And if you're a family of 4, that's £10,000 for the Home Office. So you can apply for a fee waiver. So a fee waiver is not the application. A fee waiver is asking the Home Office to say, listen, I can't afford to pay these ridiculous amounts that you're charging me, 10,000 for my family. I don't have the money. So can you give me a pass so that I can apply for this leave to remain? So the fee waiver is free. You don't, the Home Office doesn't charge you, obviously, to apply, and you're asking them to assess your financial circumstances and give you a code so that you can then apply. But what happens when you do this fee waiver is your right to live here lawfully, it continues. So you are allowed to continue living here legally. And whilst you're doing that, if you get a switch in that time, you can then apply for a switch. If you don't get a switch, you will then get a decision at the moment about 6 months. It's taking about 6 months. So you can get a decision and then you apply for the further leave to remain. which again is taking about 12 months. So that gives you another 18 months or so. And during that time, you are looking for a job, like literally just looking for a switch. If you find one at any point, you can vary your application and make an application as a skilled worker again. It gives you time, and it allows you to extend the time so that you don't become an overstayer. At the moment, there's delays in how the fee waivers are processed, and that's an advantage and a lifeline for many people. But it's frustrating for other people as well. So the number of fee waivers that have been applied for has risen by such a high number. I saw an article in The Guardian about this today. And it's because of the demands. Because of the increase in the fees, and then because of the number of people who are applying. So it's really so that's how you can apply for the fee waiver. Yeah. And then how do I prove my right to work? You can prove your right to work by asking your employer to do what's called using the employer checking service to see if you get a positive verification. So if you've applied for a fee waiver, it should show that when the employer does the check using the employer checking service, that you are permitted to work. So I would encourage you to do that. I want to encourage everyone to please use, the questions that I haven't been able to answer tonight is there are lots of questions. However, please use our facility on our website, which is we have a chat facility on our website. So we're going to feed some of the questions that you've asked to feed the answers in so that you can use that to get answers 24/7. The chatbot is so good. I love it personally. I even chat to it sometimes when I'm a bit bored, and I just go on and chat and say, "Hey, Uriboere," because it speaks Shona, it speaks Yoruba, speaks Ndebele, speaks Twi, any language, Urdu, Gujarati. You just type and you say, "Hello, Salibonani," and it will speak to you. Can you help me to get a switch? Have you seen any jobs which offer sponsorship? Can I change from simple questions you can ask? So some of the questions that you're asking here, we usually feed with information, commonly asked questions, and we help the chat facility to become quite personalized to the issues that we see people asking. So you're not going to get hold of us. We can't, you're not going to be able to get hold of me. We also have appointments, but our appointments are booked up. We are trying as best as we can. And I think everywhere across the UK, most of the immigration lawyers are full because there's such a demand for immigration advice. And people can only do what they can do. So we do try our best, which is why we even do these Zoom meetings so that we can answer some of the questions and help people by giving them information. And that's why we've also got this facility on our website, which can give you information. It's not a replacement of legal advice, but it answers commonly asked questions. It can lead you to the gov.uk website. It can help you with links. So you can get quite a lot of information there in a language that's comfortable and preferable for you. So I encourage you, please, to use it. We've invested a lot of time and effort into getting that chat facility for people. So please take advantage of it. And the questions that we haven't been able to answer today, we will feed that information into our chat facility. So So what happens if you're overstayer? If you're an overstayer, you don't have right to work. So you become an overstayer. Like I've said, don't become an overstayer. There's no reason for you to become an overstayer because you have got all the information that you need. When we came here, we didn't have a lot of information. So you've got information. Please utilize it and don't become an overstayer. If you've got a 60-day letter, don't rush to apply for a fee waiver. Put your attention on looking for a switch. And then if it's about to run out and you've got like 3 weeks, then you can start applying for it or coming to get advice or help. I remember one of our clients, she had a 60-day letter. It was expiring her 60 days was expiring last week on Sunday. So we submitted the fee waiver on the Friday, but she got a switch from one of the sponsors who we work with. She gave her a switch. She was able to apply for her field worker visa on the Sunday, just before her visa expired, and she got her visa in 2 days. So that was really nice. But she waited until the last minute. So I would always encourage you to wait until at least a week or two because you don't really want to apply for this fee waiver. What you really want to do is stay on the route that you're in so that you can continue to extend as a skilled worker. That's the best thing. So I'm really sorry for those people that we didn't manage to answer their questions. I hope that this session has been useful for you and you've taken something away. If we haven't been able to answer your question, please jump onto our chat facility. The link has been shared here. Please use it and ask any questions that you have. Some of the other questions that we have, we're going to download them and then feed them into the bot and also use them for for content. Please follow us on our social media. I'll hand back over to our host for tonight just to finish off. It's 9 o'clock. Yeah, brilliant. Thank you. You've got all of that. You can book consultations. You can follow us on social media. You can, if you live in Coventry or Warwickshire, you can come to our drop-in tomorrow. We're there for people in Coventry and Warwickshire, please. We've had to restrict that so that we're able to just support people in the local area. We have a drop-in tomorrow. Or else visit our website and get all the as much information as you can. Wish you all the best and be blessed and take care. I'll hand over back to Tendai.
Thank you so much, Rumbi, and thank you everyone for joining us tonight. So at Tulia, some of the things that we do is legal advice on UK immigration, visa applications. It can be a skilled worker visa, visitor's visa, dependents. We also help with appeals and administrative reviews, settlement, British citizenship applications, and more. And like Ruby said, we've got a Let's Chat feature on our website, which is really, really helpful. So all those questions, if you did manage to get your question answered, the Let's Chat feature will definitely help you any time of the day, even in any language. So please don't hesitate to use it. You can ask as many questions as you may wish. It never gets tired. And so these are some of the things that you can do. You can book a paid or a free consultation on our website. And also, please do follow us on our social media platforms, Facebook, Instagram, YouTube. We also post these recordings on our YouTube channel. So be sure to look out for this recording probably by the end of this week or early next week. You can also volunteer to work with us or use our WhatsApp number if you need any help. We'll be very happy to help you. Otherwise, thank you all for joining us and have a blessed evening. Goodbye.